It's a convention. It's a convention of the people of the states. What they said in 1787 was, "We, the people of the United States." And in like manner, an Article 5 convention would be a convention of the people of the states. The people who created the Constitution, it was the people that can amend it. And the people would have to be the ones that would propose amendments to fix it.
It comes up a lot when I talk to people about Article 5. They say, well, if we did that today, it would just become a convention of the oligarchs. How do we make sure, how are we confident that these delegates are going to be elected or chosen by the people or of the people rather than the selection of state legislatures?
Well, that of course brings me up to discuss Convention USA, which is something I started about 5 or 6 years ago, and it's on the internet. And the purpose of Convention USA is to bring together patriotic Americans all over the country who are interested in having a constitutional convention and participating in it. And the idea is to find people all over the country who want to occupy those seats and who are willing to participate in the convention. Now, they're not necessarily all going to go to one place, but they'll be able to be on the computer and to vote on issues that are presented and discussed and debated before the convention.
Would you prefer to have the American people, the common people, deliberating about this, or would you rather have people that are trained and skilled to write laws do this specifically?
My book begins with the story of the Massachusetts Ratification Convention, in which I describe a debate, in effect, between two farmers, and they were debating the ratification of the United States Constitution. Neither one was a lawyer. Neither one of them was a college professor or a scholar of the law. But they were citizens, and they had read the Constitution, and they had different opinions about it, and they spoke quite eloquently about their respective positions. But that was the fact in 1787, 1788, and 1789, that the people of the United States all across the board were engaged in a debate about the Constitution. And what was said, and I can't recall the man who said it specifically, but what they said, and he was a delegate to the convention, is that the Constitution is written in the plain language of the people, and that was the intention of it. And there's no reason why farmers today, businessmen, school teachers, policemen, you name it, cannot understand what the Constitution says and recognize the meaning of amendments to the Constitution and what they should be saying and how they should be interpreted. Because I mean, the whole idea of the language is for people to be able to communicate with one another and understand what they're talking about. So I say that the Constitution should always say what it means and mean what it says.
Is the right to alter and abolish, or to abolish, is that rhetoric, or is that a real right?
Well, the Declaration of Independence speaks about rights that are given to us by our Creator. Whatever your religious affiliation or belief is, it seems to me that everybody has to recognize that there are certain natural rights that human beings have just by their own very nature. And the fact that we are creatures with a free will, creatures who have our own opinions and our ability to decide how we're going to spend our time or what we're going to do, what we're going to believe, it seems to me is so self-evident to everybody who is rational and reasonably intelligent, that the whole idea of the foundation of the Declaration of Independence is self-evident, and that's what they said. These rights are self-evident: life, liberty, and the pursuit of happiness. And we're endowed by our Creator, and that is no law, no government creates those rights. Those rights are created in the nature of human life And so nobody can take them away from us either. Of course, Dan, what you have to remember is that under Article 5, the ratification by the states is subject to a decision by the Congress as to whether the ratification is by the legislatures in the states or by conventions in each of the states. And in fact, of all the 27 amendments that have been adopted to the federal Constitution, only one of them was ratified by way of conventions in the states, and that was repeal of prohibition.
Right.
But so the Congress has a role to play in making a decision as to whether the ratification is going to be by legislatures or by conventions in the states. Now, consider this, just for a hypothetical case. Suppose a convention is called by the Congress, and suppose the convention proposes an amendment limiting congressional terms to 12 years or whatever. And then it sends that proposal to the Congress and says, okay, now send it out to the states to be ratified. And the Congress considers it, and they can't get a majority vote in both houses to send it to the legislatures or to send it to the conventions. The House of Representatives wants to send it to the legislatures. The Senate votes to send it to the conventions in the states. And they bicker back and forth. They never agree. So now, will that amendment ever be ratified? Is there any way for it to be ratified? If the Congress won't decide how it's going to be ratified, is it just going to sit there unratified, proposed properly by the convention, but never ratified because the Congress won't agree on how to have it ratified? No, so I think the fact of the matter is that Article 5 has this fatal flaw in that it has given the Congress the power, first of all, to call a convention, and secondly, to determine the method of ratification. So the Congress has got a stranglehold on it. The Congress has got, in effect, a veto. There's no way directly that you can amend the Constitution without the approval of the Congress. Now, so people ask me, what can you do with this convention that you're trying to create of citizens, people's convention? Okay, you can't stop them from getting together. You can't stop them from debating and passing resolutions. And you can't stop a group of citizens, however they're chosen, who've come together to be a convention. You can't stop them from proposing an amendment. I mean, after all, Mark Levin has proposed amendments. I proposed amendments. A lot of people have proposed amendments. All you got to do is have a piece of paper and write the convention, write the amendment that you want to propose. So everybody can propose amendments. So here's a convention of citizens from around the country that have proposed an amendment. What's going to happen to it? Will it ever become part of the Constitution? Well, I in the book I point out four possibilities. The first possibility is that nobody pays any attention to the resolution, the proposal by this rump convention, okay? It just goes by the wayside. That's pretty obvious that could happen. Second possibility is that the proposal, once it's been adopted by the convention, goes down to Washington, and the congressmen and the senators say, oh, that's a great idea. We're going to propose it. So they then can propose it by a 2/3 vote in both houses. And then, is following Article 5, that can go out to the states to be ratified. Or the third possibility is that you don't have 2/3 of the votes in the House, and you don't have 2/3, or you don't have the votes in the 2/3 vote in the Senate, but you do have a majority of both the Senate and the House. So the majority of the Senate and the House calls the convention, this rump convention, it labels it as an official convention. And then it accepts the proposal coming from the convention and sends it out to the states by a mere majority of both the House and the Senate. So if you have a convention, if there is actually a convention called, it's called not by 2/3 majority of both houses, but by a simple majority of both houses. And the method of ratification is to be determined by a simple majority in both houses. So that's the third way it could happen. Now, the fourth way it could happen is simply this. The convention meets, the convention comes up with a proposal. They don't even send it to the Congress. They send it to the states. And they say to each state, here's a proposal. We want you to do two things with it. Number one, we want your legislature to ratify it. And number two, we want you to call a convention for the purpose of ratifying it by the citizens of the state. So now you have a proposal which has been ratified in both ways. That is, by the legislature and by a convention. And that because they've done it both ways, they've eliminated the necessity of the Congress deciding which way to do it. So since it's done both ways, the Congress is now out of the ballgame because they have no say in the thing one or the other. Now, I think if that were to happen, Dan, I gotta say, you would be confronted with a constitutional crisis of the first magnitude, because you would have the states through their legislature and through conventions of each state saying, we want this amendment to be adopted to be part of our Constitution. Now, what is the Congress going to say? Oh, we're not going to do that. We don't recognize that. I think they're smart enough to know that the next election they're going to have to face these people, and so they're going to agree. But nevertheless, I confess that is a completely extrajudicial or outside of the framework of the Constitution way of doing it. But I think it could be done.